Good evening, everyone, and welcome to this event tonight. It's hosted by LSE Middle East Center and LSE IDEAS. My name is Reem Turkmani, and I'm chairing this event tonight, which is designed to launch a special issue titled The Arab Constitutional Response to the Revolutions and Transformation in the Region. Before I hand into our three speakers, I would like to give you a brief overview of the project and the collaboration that led to the publication of this special issue. It is the result of 2 years collaboration between the Arab Association for Constitutional Law, which is headed by Tamara Khouri, and the Citizenship and Legitimacy in the Arab World research project, to which I'm the principal investigator. The project is based at LSE, started in 2019, and is supported by a generous grant by the Carnegie Corporation of New York. But first, let me address the question of why did we decide to look into this topic? Why to look into constitutions which are rendered as irrelevant at best in the Arab world? Originally, they have been designed to limit the power of the people rather than the state. The way they've been written, always from the top with complete disregard to the demands of the people, the way they were implemented in a very selective way, indeed have led to a massive gap between the constitutional promises and the actual practices. But if we actually read very carefully in the slogans of the Arab Springs that started 13 years ago, we'll find that the demands all pointed in the direction of the Constitution. Dignity, equality, social justice, end of tyranny, they're all necessarily linked to the principles upon which the state operates. And despite the very unfortunate history of constitutionalism in the region, and despite the disheartening experience of the Arab Spring, we see now that constitutions are occupying again a center stage, signaling just how much they actually do matter. There is no denying now that ordinary citizens across the Arab world became acutely more aware of how important constitutions are, and they are demanding more legitimate constitutions. The awareness level with the general public with respect to constitutional matters is increasing significantly. And we're seeing this in many demonstrations across the Arab world. This is a picture from one of the demonstrations in Syria, I think around 2016. People clearly asking to take part in shaping their state and saying it's the Syrian people who actually decide what kind of state they want. There's another demonstration from Iraq, 2019, clearly naming the constitution as the one thing they demand, and they're saying down to the Bremer constitution. Bremer was of course, the American civil governor of Iraq in 2005. They're calling for no sectarian quota, for no privatization. So they're saying clearly what do they want in a constitution. In Tunisia, we've seen even demonstrations trying to protect the constitution against the constitutional coup in 2021. So we noted the importance of this matter, and that's really what prompted this collaboration, and that we really need to investigate this issue further, because it has been ignored in the literature. This is despite that actually within 2 years, between 2011 and 2012, we've seen 7 constitutions in the Arab world changing. This is exactly the number of changes in the entire Arab world during 10 years before 2011. So certainly there has been a response, but it hasn't been studied. Did it really respond to what people wanted? Was it preemptive? Did it resolve any issue or not? And that's what we wanted to look at. So we worked in collaboration with tens of constitutional experts, political scientists, scholars from across the Arab world, together with the Association for Constitutional Law, in this project to write 10 papers investigating this question in 10 Arab countries. These are Tunisia, Egypt, Lebanon, Algeria, Syria, Yemen, Libya, Bahrain, Morocco, and Jordan. They worked in small teams to produce the papers addressing this question in each country, and we convened in a conference in Beirut in December 2022 to debate the initial findings. I'm trying to get some pictures from the, this is the special issue that we produced. It's bilingual in Arabic and English. It's available at the website of the association. These are some pictures from the conference in Beirut. I'm particularly proud of the female participation. I mean, half of the authors and speakers were all Arab female scholars and experts. We have 2 of them here with us today. And we produced this bilingual issue, which was co-edited by myself and Tamara. But the experience was much more than just producing this paper. I mean, the whole experience provided like a space for collaboration and networking and continuing the debate between this community on very topical issues, because events continue to, change in the Middle East, require always further reflection. We're planning to continue this collaboration, continue working with this very, very vibrant community. At the end of the conference in Beirut, I'll show you, this is the picture of all the participants. We asked people, what do you want us to work on next? And most of people pointed at one thing, which is, what is a civic state? I don't know if many of you are probably aware of this concept called civic state, often used in the Arab world, in Arab constitutions, and Arab manifestos of Arab political parties to define a state. Although the concept itself is not defined, often used to hide very uncivic arrangements. So people want to deep into this. What does it mean? Does it work? How can we define it? What are the issues in different Arab countries around this? So that's what we're going to work on next. And I hope that next time I'm going to be here, I'll be talking about the results of our collaboration. Before I introduce our first speaker, just a few housekeeping notes. So we're going to start with 10 minutes to each speaker, and we're not going to take questions and answers during which, so there will be lots of room for questions from the online and in-person audience towards the end. And we're going to end exactly at the breakfast breaking time, so there will be a small reception outside. So our first speaker is Dr. Tamara Khouri. She's the Executive Director of the Arab Association for Constitutional Law. She's also the editor of the Journal of Constitutional Law in the Middle East of North Africa, which published the special issue. She's a constitutional expert at the Max Planck Foundation for International Peace and the Rule of Law. She has been involved in constitutional and institutional reform processes in Libya, Jordan, Mali, Somalia, and South Sudan, working extensively in both institutional actors and with civil society organizations. She also teaches constitutional law at the IE University in Madrid. So, Tamara, you're our first speaker.
So thank you, Reem, and good afternoon, everyone, and thank you for joining, whether in person or online. I'll now move on to provide an overview of those 10 papers that Reem mentioned. And I'll do so by first referring briefly to the context in which those constitutional changes unfolded across the region. I will then attempt to emphasize what aspects were under analysis in each of those papers, and last but not least, point to key findings with respect to each experience. And on that basis, we'll leave it to Professor Nathan Brown to also attempt to identify trends that perhaps can be considered of a regional nature. So briefly, with regards to the context, with the exception of Lebanon, which was included among the 10 countries, all of those countries, as Reem said, underwent some form of constitutional change in the wake of the Arab Spring, be it via constitutional amendment or outright constitutional replacement. And I think from a comparative perspective, it's also useful to think of those countries in smaller categories. So if we were to begin with Tunisia and Egypt, which ushered in that decade of, or rather decade plus of constitutional change, it is, I think, important to note that both countries engaged in constitution making in deeply polarized contexts. That would be, I would say, the key factor, very much marked by popular and electoral support to the Muslim Brotherhood in the case of Egypt and Ennahda and Tunisia. And yet, while Egypt's two successive constitutional processes, so leading to the 2012 and then 2014 constitutions, exacerbated divisions, perhaps even entrenched them, Tunisia did engage in a genuine attempt at containing that polarization through what was termed a consensus constitution. That was in 2014, obviously, before the constitutional coup. Now, when it comes to Algeria, Morocco, Jordan, Bahrain also, to a large degree, it can be said that constitutional amendment processes in those countries were largely preemptive, meaning that those countries basically sought to contain those initial waves of unrest that had elsewhere successfully toppled long-ruling heads of state and addressed, or at least purported to address, some of the people's demands for democratic change. Then come Libya, Syria, and Yemen in another category, to the degree that, well, protests were immediately or almost immediately met with violence and repression. All of those countries have since experienced different degrees of internal conflict and strife, perhaps fueled too very much by external actors. But so I would say one common factor here is that constitution making unfolded and continues to unfold in a context of armed conflict, and therefore it cannot be considered in isolation of broader attempts at conflict transformation, even peacemaking to a certain degree. In terms of what aspects were under analysis, if we were to go back to what Reem mentioned in terms of the question of legitimacy and the deficit in legitimacy in the Arab region, it was about attempting to determine the degree to which these constitutional changes across the region have been successful 10, 13 years down the road in meeting those popular demands. And so for that, we asked our authors to focus on a number of matters, amongst which I'd like to mention the process itself by which those constitutions were amended or made, and the degree to which it was inclusive, participatory. It is, I guess, almost a point of consensus that for constitutions to be accepted as legitimate, the processes by which they are made ought to be inclusive and participatory. The other question focused on the content of those constitutional amendments, and of course, the degree to which they were geared toward enhancing the protection of rights on the one hand, and institutional design, again, aimed at redistributing or deconcentrating power away from those hyper-presidentialist models that have very much characterized the region, or monarchies that still are yet to become parliamentary in nature. And last but not least, an oft ignored question, which is, well, where constitutional amendments did introduce positive changes, how effectively were they implemented? And if not, was it a question of a lack of political will, or is it that they had no impact because ultimately there were ingrained power structures that remained unaltered? And so now briefly with regards to what the papers tell us, and of course I'm not going to go into much detail, you are warmly invited to read them. Again, I'll follow the order we followed in the paper because it also applies those categories. Of course, when it comes to Tunisia, it was the sole success story for a long time. We all know that ultimately turned out not to be the case, but it did tick all the boxes: inclusive, participatory process that yields a constitution that, one, is the fruit of political compromise, but furthermore does lay the ground for a democratic regime that was hybrid in nature, precisely to move away from those hyper-presidential politics of the past. And yet, it failed. And so the author, Dr. Muna Tabi'i here, posits that the failure had primarily to do with the fact that it was selectively implemented. Perhaps the quest for compromise did yield ambiguous provisions, particularly with regards to distribution of power between the dual executive authorities. And perhaps that ambiguity didn't aid implementation. But ultimately, the fundamental guarantee contained in that constitution was the constitutional court, with broad powers to hold powers or the authorities in check, but fundamentally also uphold rights and freedoms. And that constitutional court was never established. It should have been established within a given time frame, following the entry into force of the constitution. It never was, because of a lack of, well, political consensus on the appointment of its members. And I guess the fundamental insight into that experience is, well, what kinds of mechanisms can we think of to ensure that well-designed constitutions that do have mechanisms that guarantee rights and freedoms have also incorporate mechanisms that guarantee their implementation? I don't think we have found the answer yet. When it comes to Egypt, and briefly, Dr. Ahmed Morsi here doesn't necessarily engage in a comparison of the two processes, again, 2012 to 2014, but rather asks a question which, again, applies to many other Arab countries, and I would say even beyond the Arab region, which is to say, how do you strike a balance in a moment of constitution making, which again follows the fall of an autocratic regime and revolutionary fervor? How do you strike a balance between, on the one hand, this idea that there are forces in place and you need to a certain degree to reflect those forces and the balance between those forces, but at the same time produce a constitution that can accommodate the transformation of those forces and other balances in the future? And well, basically the crucial insight is that rushed constitution making, especially in political environments that are unstable, if anything, can entrench those divisions rather than allow for the generation of long-term consensus. When it comes to Lebanon, again, this is indeed a country that did not undergo any kind of constitutional amendment in what was termed the Arab Spring, but I think the author makes a compelling argument here that it became relevant in as much as a lot of the challenges that were faced elsewhere when those countries did engage in constitution making had to deal with the accommodation of pluralism, diversity, and there's Lebanon and its own experience with sectarian, well, or confessionalism, if you may. And so I think what the author asks is, well, the state has failed to transition into a state based on the rule of law because it basically kind of succumbed to the interests of the leaders of the different sects and their factional interests, which of course go against the general interest. But what she asks, and I guess it's the question that again other countries can ask themselves, particularly Iraq, even if it's not included here, is, well, is it that those sectarian foundations simply need correctives in order to function and to accommodate that plurality, while at the same time allowing for the state to assert its sovereignty and enable citizenship? Or is it that you need to really get rid of those sectarian foundations and you're toward a different kind of model? Briefly, in Algeria, I think this is the prime example of a country that undergoes amendments that, again, tick certain boxes, a constitutional court that guarantees indirect citizen access to it, liberties that are at least on paper enhanced, and yet, at least I would say the key insight is that constitutional court was implemented, it was established, unlike in Tunisia, but it remains highly underused. And again, a reflection in terms of what, well, does the establishment of a constitutional court in itself suffice, or are there power structures that remain fundamentally unaltered despite the 2016 and 2020 amendments? On Syria, I know there are a few experts in the room. I'll refer to what Dr. Brahim Daraji here, I think, focuses on, which is, let us not ask whether the process was inclusive and participatory in 2012, when the constitution, again, following a top-bottom approach, was adopted, but rather whether there was, to begin with, a context that enabled effective and genuine participation amidst the obvious lack of any kinds of trust-building measures to create that environment. And I think this speaks to what Reem said earlier about constitutions that actually serve authoritarianism. Dr. Daraji's conclusion is that ultimately the 2012 Constitution did not establish a new political system, even if it introduced political pluralism, again on paper, direct presidential elections. What it did was actually provide a new constitutional framework for the existing political system. It enhanced its powers, and it basically legitimized its dominance, further exacerbating, if anything, the crisis. I'll be brief in Yemen. I think the distinctive feature here and that hasn't received much attention beyond the region with regards to Yemen is that that country, despite its conflict, did engage in a wide-ranging, comprehensive national dialogue process that was generally participatory and inclusive, and that has or served as the foundation for the constitution-making process, which again yielded a draft constitution that is yet to be adopted, but, and I think it speaks to the Libyan experience, invites us to maybe start thinking also about constitution building as a longer-term process and in terms of incremental constitution building. So what the author here says is that national dialogue did lay the foundations, and even if the process at the moment is stalled, we can still build on it, and it's an ongoing dialogue in a sense. On Libya, I'll defer to our colleague, Ms. Azal Makoud, who will walk us through the intricacies of that process. I'll conclude with a few remarks on Bahrain, Morocco, and Jordan, all of them monarchical systems. The key insight with regards to Bahrain, according at least to the author's analysis, is quite interesting, because basically what the author claims is that this idea that was introduced through these amendments when it comes to sovereignty, about the joint will of the people and the king, which is repeated numerous times in that constitution, is basically constitutes the generalization of the interests of the ruling family at the expense of popular will. And the interesting reflection here is, well, constitutionalism can be pitted against and operate against democracy, against popular sovereignty. So I think a lot to reflect on there. Again, with regards to Morocco, it seems that although certain elements of representative democracy, of parliamentary democracy, were enhanced, at the end of the day, at the same time, not only were the monarch's prerogatives preserved, but rather enlarged. It's this very contradictory system that features some aspects of presidentialism and what he refers to as post-parliamentary governance, where again these agencies, right, identified with neoliberalism or neoliberal constitutionalism, well, they basically render any form of popular sovereignty irrelevant. And last but not least, with regards to Jordan, I think the title itself is pretty telling. The author speaks of a coup against the parliamentary system. I think what's interesting is that everyone focused on the 2011 amendments in Jordan. Again, establishment of a constitutional court. People stopped paying attention by 1214, where successive amendments were introduced, and they not only again limited the monarch's power, but rather incremented it, but not just incremented it, but rather in doing away with any kind of counter-signature of the Prime Minister when it comes to key appointments of key elements when it comes to the intelligence, to all other institutions in the state, you reach a system which supposedly in monarchies the king can do no wrong, but if the king can do no wrong, it's because political responsibility lies elsewhere, because political decision-making lies elsewhere. But there's a system where decision-making is increasingly concentrated in the monarch's hands, and at the same time, no responsibility, full immunity. And, well, the author basically concludes that one can no longer speak of a parliamentary monarchy when it comes to the Jordan constitution taken, again, against all those successive amendments. Now, I'll stop here because I think I spoke a bit more than I should have. But as I said, Professor Brown will later try to identify certain common trends across the region. Thank you.
Great. Thank you so much, Tamara. Very comprehensive overview. So our next speaker is Azza Kamel Magour, who's a Libyan lawyer, human rights activist, and constitutional law expert. She is known for defending political prisoners, advocating for human rights, including women's rights, NGOs, openly calling for constitutional change in Libya. She headed the legal committee to draft the law concerning NGOs in Libya, and she worked on further legislations, including the election law of 2012.
Hello, everybody. I'm very happy to be here today and to speak about the Libyan constitution-making process. Before I start, I just want to tell you that members of the team that has participated in this project, most of them actually participated or they didn't only witness the revolution, but they were part of it, and they also participated actively in the process, either the democratization process or the constitutional process. So I'm here not to talk to you from my mind, but also from my heart. Now, the title of this talk is The Trajectory of Libyan Constitution Making, and I say it's a mission unaccomplished, and I'm not saying a mission impossible of Tom Cruise. I would start with a verse of the Quran: such days we alternate between the people, وَتِلْكَ الْأَيَّامُ نُدَاوِلُهَا بَيْنَ النَّاسِ, or what is said in the Encyclopedia of Philosophy for Stanford University, political revolution. And this is right, it's a political revolution, because you have different revolutions in the world. Transformative moments marked by profound, rapid change in the political order achieved through the use of force rather than through consensus or legal process. And I end up with, or no, before ending up, I would say John F. Kennedy gave it a different meaning. Those who make peaceful revolution impossible will make violent revolution inevitable. But Andy Milligan, the English writer, said, what does the country need right now? And I don't know which country he's speaking of, but 3 things: a revolution, then a revolution, then when the dust has settled, a revolution. And that's what we are hearing again and again in the Arab world these days, for asking for other revolution. And of course, we don't want this to happen again. So what is the particularity of the Libyan experience? What is unique in the Libyan experience? In 1951, Libya gained its independence by a General Assembly resolution. But before declaring Libyan independence, 2 months before, Libya has its new constitution. So the constitution was before declaring Libyan independence. However, the constitution of Libya, of the Kingdom of Libya at the time, only lived a short period of 18 years. Therefore, I don't think that it was entrenched or rooted in the Libyan conscience at the time. And when the coup d'etat happened in 1969, or we can call it also a revolution at the time, if you have any question on that, I will answer. But when 1969, nobody went out and said, no, don't touch our constitution, leave it or amend it, but keep it. So there was no defense for this constitution. Since 1969 up to today, we have no constitution. So we lived 43 years with no constitution at all. There is no C, big C, you know, the C constitution. We had some sort of constitution declaration in the beginning, but it was dissolved by itself. Then we had the documents, fundamental rights, and all of these things, which are not actually a constitution. And what Reem said this today, she showed these banners of people saying, we want a constitution. Libyans in the streets had this banner and said, we want a constitution from day one in Benghazi, I remember. But however, in 2011, we had a constitutional declaration. This constitutional declaration is not too big. It's a mini constitution, but they have different sections. The first section, which is important, second section important, speaks about human rights and liberties. And I think this is one of the best, maybe, pieces we had in relation to human rights and liberties. And I think it reflected right away the feeling at the time. Later on, as you will see later on, the draft of the Constitutional Assembly did not really reflect the rights and liberties, and it decreased what we gained actually in the Constitutional Declaration, which is very bizarre, if I may say. But what is striking in the Constitutional Declaration is the simplicity, maybe the naivety. I don't want to use this word, but I would say the simplicity and the optimism at the time. And so for Libyans in 2011, we thought constitution making is a festivity. It's something nice. It's positive. It's a long-awaited aspiration. But maybe it wasn't as we thought at the time. So this is how just to show you, well, we can talk about this later, how to show you how simple was the Libyan dream of democratization process, of coming from how we go from a simple transitional period to a stable period. This was, look at this. This is very simple. It looks very nice, very simple, and very neat. And then what happened is this. Look at this. This is what happened. Just, I don't want to go into details, but all of these round what I call them the crisis, the constitutional crisis. So 1, 2, 3, 4, there was a war in between, and it continued. Even today, we still have a constitutional crisis. So this is the reality, and this was the dream. And the dream is the Constitution, is the Constitution Declaration. So the Constitution Declaration at the time, it was the dream. But the reality was different, and I think Tamara talked about the Tunisian experience and how it was a dream in the text, but the reality was maybe different. So how was the Constitutional Drafting Committee formed? The Constitutional Drafting Committee was formed by, of course, as I said, the Constitutional Declaration in 2011. The composition was within the GNC. The GNC is the first elected body. It's a legislative body with some executive power. But so it was within, very simple. And they were asked, in the Constitutional Declaration, it says in 60 days the Constitution would be ready. In 60 days. If I go to the kitchen, I may need more than 60 days to do something. And then the first amendment, the GNC gave up the CDA because of the federalist movement at the time. So you will see the implication of the, what I call them, the revolution dynamics at the time. So the revolution dynamics had an effect on the constitutional process, as you see now. So the federalist movement said, no, we will not participate, we will sabotage the elections if you don't allow, if you don't take off the CDA out of the control of the GNC, the General National Congress. And they succeeded. So the CDA became out of the control of the GNC. Not only that, but they limited the numbers of 60 because they said we want to have each region the same numbers, whereas of course, for example, in some regions you have more population than others, but they, and here you can see this was the first test of national reconciliation, and we succeeded in this. People said, okay, we will have 60, doesn't matter, we just want the Constitution to be issued. The third change is when people went in the street and said, GNC, you have no whatsoever power on the Constitutional Drafting Assembly. Again, you have the dynamics of the people, or out of the revolution on the constitution making. And here they said CDA, Constitutional Drafting Assembly, should be elected. And of course, because the GNC did not perform well, so people were very worried that they will have an impact on the GNC. So the CDA. So we managed, or Libya managed to have the CDA as an elected body and not an appointed body. But the problem here is that there was no protocol between the GNC, the CDA. So you have two elected bodies who are in concurrence, of course. We saw this coming, and we told them, be careful, you have to have a protocol, you have to have some sort of an agreement between the GNC and the CDA. Nobody listened, and later on, there was this of course, sort of disputes or whatever differences, if I may say. What is happening today? Today, we still have the Constitutional Declaration of 2011, but which is okay, it's still functioning, but not fully, especially when it comes to governing, state governance. It has nothing to do with it anymore because it has changed with what I call it the political arrangements. Because the drafting assembly, the CDA did not perform its job efficiently and on time, then war started to happen in Libya and to take place in Libya. Therefore, the UN interfered, and we started to have political arrangements. What does that mean? That means it's also a process that is related to constitution, because it's related to the governing of the country, but it's not under a constitution. It's arrangements, and these arrangements now are in effect in Libya. These are by which Libya is now governed, by these political arrangements. You have heard, of course, about the political agreement and then the roadmap in 2020. So what is governing Libya today? It's not no constitution, no constitutional declaration, but it is these political arrangements which are very precarious and unsustainable, and you never know how long it's going to sustain based on these documents. How much? Oh, goodness. Okay. I said it's a mission unaccomplished because there were lots of boycotting from the members, the disputes. There was no mechanism, internal mechanism to solve disputes. Members would go to court all the time to stop one decision of the CDA or another. So today, the CDA issued 2 drafts, one in 2017, one in 2019. I can answer any question in that regard. But today, the CDA is paralyzed. It's doing nothing. And Libya is run by, as I said, political arrangements. I will talk about this later on if you have any question why this mission was unaccomplished. The way out, I think the way out is going to take some time. And I think it should be within the umbrella or under the umbrella of national reconciliation. As long as now we are governed by the political arrangement, we should start, or we should have started this long time ago, a process of national reconciliation that will elucidate the way forward to write or to produce the constitution. There aren't much differences in the drafts, and we know where are the differences. So this is already, at least, this is something that the CDA has done. So constitution making is history making, in my opinion. After 13 years, the revolution dust has settled, but the painful and long democratization process was launched with its surprises, full of surprises, believe me, successes, disappointment, and failures. We should not judge the region's post-revolution trajectory yet. We should simply be aware and stay alert of our long, painful destiny and never lose hope. I told you in the introduction that change is the essence of life. Thank you very much.
Thank you. Thank you very much, Azad. That was very interesting. So our last speaker is Professor Nathan Brown, who's a professor of political science and international affairs at George Washington University, and he's non-resident senior fellow at the Carnegie Endowment for International Peace. He's the author of 6 books and co-author of 4 and editor of 4. Among his work are The Rule of Law in the Arab World and Constitutions in Non-Constitutional World, that is the Arab world. And he was with us in the conference in Beirut. He listened to all the interventions, all the debates, and he gave us his reflections in the last session, and he's going to share with us his thoughts and remarks on this non-constitutional Arab world. Thank you.
Thank you very much, and thank you very much for having me here at LSE and to the Arab Association for Constitutional Law. We've just heard a quick overview of 10 different cases, that each one is rich and complicated. We got a detailed view of one case that was rich and complicated. I'm going to try and sort of give an overview of the region as a whole. And it's a tough task. It's a tough task because there was an awful lot of expertise in the room. And one of the questions I have to ask is, I'm not a member of the Arab Association for Constitutional Law. I wasn't a revolutionary, right? I wasn't one of the people who wrote one of these 10 papers. So why me? Why am I the one who's doing this? And I don't think it's necessarily for any reason other than I've just been working on the Arab constitutions for a long time. So it's age that got me to where I am right now. When I started 3 decades ago, and it was 3 decades ago that I got interested in Arab constitutional texts, it was, I hope I don't sound excessively flippant if I say that you didn't have to be very good at the work to be among the top people in the field, because there weren't a lot of people who went into it. And the reason, actually, Reem said it sort of in her opening remarks, constitutions seem to be ways in which essentially existing regimes constituted the political system rather than the other way around. They were ways, if you took a look at these documents, they were basically ways of regimes saying, here's what we're going to do, period. Or they were full of very, very vague promises, the one that sort of Reed mentioned, that when you looked at them, there was no real way to implement them. So that it didn't look like a place to look to take politics or even law all that seriously. And then we have this tremendous change. There actually was some period before 2011 when there's a lot more level at an intellectual interest and sometimes at a political level at talking about constitutional issues. This didn't suddenly burst forward in 2011, but of course in 2011 burst forth with tremendous force. And suddenly it was not the old cynicism that I had been accustomed to, but idealism that seemed to be motivating an awful lot of political action. And a very different way of looking at constitutions. So Tamara gave you a quick overview of each of the papers. I'm going to just actually pick one word from each title of the paper and then suggest what's different about the way that they're looking. The words are transition, effectiveness, imposed, constitution making, crisis, process, narrative, creating, shifting, coup. And when you listen to those words, you notice something, or at least I notice something. These are all very active words. These are things that people are doing, people are arguing about, people are contesting, people are trying to change. Suddenly, if you look at works on Arab constitutionals prior to this period, what you see is an awful lot of emphasis on text. Article 12 says this, Article 15 says this, and this sort of things. There's a lot of to use the phrase, black letter law in constitutional analysis, and suddenly there's an awful lot of politics and contestation and so on. And so that's really what's animating to me this collection. There are, and certainly are, there was an awful lot of legal expertise in the room, but it is not just dry legal expertise, it's politically engaged and politically sophisticated and politically informed expertise. So that to move, there's a shift away from a narrow concentration on text to a broader concentration on process, people, and politics. But when you do that, when you insist on looking at things that way, suddenly the region becomes much more complicated and much more diverse, right? Because if you look at actual text and line them side by side, there's an awful lot of similarities, and it's easy to do comparative analysis. When you start saying we have to understand these documents very, very differently and politically, you run into the tremendous diversity in the region. So what I heard in the room in Beirut and what I read in the collection is a set of analyses that are not pointing to a specific conclusion. This is what the Constitution should say. This is an ideal Constitution. Instead, they're united much more by a set of questions. And what I want to do is to talk about three of the questions, what, how, and who, and talk about what it is that the articles seem to kind of coalesce on, but also, I think, in a subtle way, in a way that you'll be hearing as much from me as from the authors, I think they point to or suggest some real problems with constitutional analysis that probably need more explanation. So first, the what question. And if there's any kind of conclusion, central conclusion that you can come to from these articles, I've already sort of suggested it. What a constitution says has to be understood in terms of the context which produced it and by which it is operating. So if you read the words on paper and you do not look at them in the context which produced them and which they're operating, you will not understand them. The words by themselves take on different meaning according to the context. And now, but here's the subtle point that I begin to notice, and I actually even heard it in some of the comments already about this what question. We think about constitutions and there's a word that comes up immediately when we think of constitutions that are rights. We think of constitutions as rights granting or rights recognizing documents, and they are and they can be. But the specific provisions that I heard about, especially when Tamara was talking, weren't so much about rights. They weren't about how the rights would be, they weren't about what rights people had. They were, the what question actually had a lot more to do with how various parts of the state interact with each other. So what is the power of the Constitutional Court? When there wasn't a Constitutional Court in Tunisia, a key state actor taken out, and what do you have? You have basically a constitutional crisis that winds up with the result that we all see. What is the relationship between the parliament and the cabinet? What are the independent judiciary? These are the sorts of things. So when I look at the collection, nobody says this explicitly, but one of the conclusions I come to is there needs to be an awful lot more conscious attention by constitutional analysts on what the state is and how the state is interacting with itself. Certainly not completely divorced from the people, but if you only look upon this as a state and a people, you will be missing an awful lot, and you'll be probably, if you're drafting, making some constitutional mistakes. Second, how? Well, and here I would say something similar. The unspoken consensus seems to be how a constitution is written can really shape the outcome. And we just heard some of the complications in Libya. And in essence, a lot of what Heather was talking about were contests over how. Who's supposed to be writing this? What's the relationship between this body and that body? They would process and why is it that people invest so much in this? It's because the how determines the outcome. How you write a constitution matters. So that's uniform across the collection. One thing that is interesting to me, that when I look at this, is the procedural questions vary considerably from one place to another, and a lot of it has to do with kind of what is the existing state of the political system? Is this a state that is in complete collapse? Is it in civil war? Tamara mentioned, is constitution writing being done in a condition in which you essentially have a recent or basically a still active civil war? Is it just a recent revolution that involved regime change, but the state is still intact? Is it being written under occupation, as you mentioned the Bremer Constitution and this sort of thing? How this, there's an awful lot of diversity. 2011 was a unifying moment, but if you actually look at the unifying moment in terms of how people understood politics, but if you looked at the political circumstances under which these various constitutions were written, they were very, very different. And finally, the who question, and to me this is actually very interesting, because the who question sounds easy to answer. And I think one of the lessons of 2011, one of the lessons of this collection is not so fast, right? Who should write a constitution? The people. Constitutions are expressions of popular sovereignty. And if there's, again, one conclusion that comes out, one central critique that comes out from these various articles, is that constitution drafting historically has not been done by the people, it's been done by existing regimes. So you really have to have some kind of viable popular process with popular engagement and so forth and so on. Yes, that's the easy answer, but who are the people, right? And I recently attended a talk where somebody defined the people in a way that I think would be very, very helpful to think of in this context. The people are we who disagree. Right? If we share nothing in common, we have nothing to do with each other, we don't need a constitution, we don't have politics. If we agree on everything, we have nothing to do. We don't need politics. The old constitutions presented themselves that way. It's kind of like the constitutions that were written by authoritarian regimes. We are the regime, we are the leaders, and we know what the people want, and here is what it is. But what do you do when the people don't always like each other? And that was a lot of the reality. A lot of these divisions had to do with divided societies. They were divided over religion, they were divided over class, over region, and so forth and so on. And how do you have a constitutional process in which these various forces come together? And in my mind, consensus is probably too high a bar. But you do need some kind of agreement among people who have some fundamentally different answers to these questions. And then the Lebanese and the Iraqi constitutions come up in this context, because you not only need people to agree, you need to allow them to change, right? A Lebanese constitution written for one particular context can freeze that context in place. And in a sense, same thing happened in Iraq. There was only perhaps one agreement that was possible under the configuration of forces that existed after the American invasion and occupation. But what that did was froze into place arrangements which many Iraqis have come to feel do not serve their society very well. So how do you write a constitution where people who disagree manage still to find some common ground for building political rules? And then how do you build rules that allow that society to develop in some ways? That to me is kind of the unspoken challenge in some of the experience, and most of the experiences that are talked about in this collection. Finally, I just want to mention one thing about the collection that is again, a little bit interesting, and again, unspoken, but I want to call attention to. So we think of constitutions as outcomes, right? Society gets together and it writes a constitution, the end. Or starting points. We write a constitution and then we start politics from there. That's not the image in the constitutions are fields for political contestation and activity. Constitutions are parts of ongoing processes. I can't remember what Tomato mentioned, constitution building, right? A constitution building approach. Okay, that was okay. That's the approach in here. And I want to kind of conclude on this note that, in a sense, what I'm saying is there's a shift in emphasis from text to context and from content to process in constitutional analysis in this volume, but there's also something about the process in production of the volume itself, because what we have here in this collection is a group of people who are not saying, here is the final answer to the question of how you write a constitution, or not even here is a final answer about how here's the constitution that should have been written for Tunisia or Libya, but here is how deeply engaged scholars examine reality, reflect on it, and reflect on what went wrong and hope to point it in more hopeful directions. So this is constitutional scholarship as political process in a way that reflects not simply what they see about constitutions, but what I think they see as their own task as engaged scholars. Thank you.
Thank you very much. Can you hear me from this? Great, thank you so much, Nathan. I'm very glad that you mentioned that all the authors were politically engaged experts and there was so much actions and the titles of the papers. This was not random. I mean, this was all deliberate because we didn't want to do this exercise to have a deep dive into the constitutional text or the dry legal language. We wanted to talk about the politics of every case, and we wanted to bring all these important debates on constitutions starting from the street and also in experts' room. We wanted to bring it to the interest of political scientists. And we deliberately chose all the people to be really politically engaged, those who were at the heart of the process in each country or very close to the process. And I think thanks to Tamara and the network of the association, after a long search, but we were able to shortlist, and you as well, we were able to shortlist the people who were engaged and able to write and reflect on this in a scholarly matter. So, it's amazing the wealth of expertise that we found on how many experts and activists there were that are hardly known to many. And they do give me hope, that especially that there is a process of learning and reflection from all these cases, and it's a long-term process, as you said. We're not hoping for a legitimate constitution tomorrow. So we're going to open the floor now for questions from online and the room, and I'll start with in the room.
Thanks to all speakers. Really, really fascinating and very, very worthy work. I really welcome that you mentioned that constitutions are fields of ongoing contestation and activity, and that change has to be accessible and inbuilt, in essence, in a constitution. I mean, it's slightly tangential here, but I think of the American Constitution, and I often feel that Americans see it as scripture, immovable scripture, rather than a document that can be changed to reflect fluid contexts. Can you speak to that a little bit?
Okay, Michael. So we maybe. Okay, Michael.
Thank you, Michael Mason, Libby Centre. That was fascinating. It's a fantastic overview, both of all the articles and the in-depth study of the Libyan example. I was really, really interested by this idea of constitution making as this performative field. And I was thinking about, end up talking about learning. I mean, in terms of this process itself, or maybe also the constitution making being studied, I wonder if you could perhaps give some examples of the ways in which there was learning between constitutions, and if there was such learning, where was the learning area Was it, if it wasn't, was it text? Was it parallel political processes, some other sources? Did that learning tend to happen within the Arab constitutional field, or were other constitutional examples or models drawn upon? Thank you.
Which constitution in the Arab world is close to the South African or Indian model?
Okay. Yeah. All right. Thank you. Okay, we'll take a question from Gharif and then answer this and then yeah.
Yes, I wonder, are we at risk of elevating the significance of constitutions in the general architecture of good governance? Because we have many examples of words within constitutions that, ring true or ring with certain values, but are never experienced on the ground. For example, in Syria, even before the uprising, the old Ba'athist constitution included articles that gave freedom to assembly, freedom of speech, freedom of forming political parties, etc. But it never meant anything of significance on the ground. So does it raise the question of whether it is the constitution that matters, or is it establishing other institutions first before you have the constitution? Because, as I said, it can be a bit of a smokescreen for governments, including very firmly authoritarian governments, to maintain their rule.
Thank you, Ray. Shall we start with these questions and then take more? So, Nathan, I think the first question maybe to you about the American scripture.
So, there are many wonderful things about the American Constitution, but to me, it is something that should always be pushed aside in a lot of comparative constitutional analysis. It is odd. I say it's like a marsupial that grew up in a completely different environmental climate. It doesn't look like other constitutions. It is short. It lasted a long time. It's extremely difficult to amend. And for that reason, a lot of if you ask Americans to quote the Constitution, most can't do it. They'll wind up quoting the Declaration of Independence, right? It is something that is important as a symbol, but most of what we take to be the basic rules of American politics grew up within the very general wording of the Constitution. But again, this is something that is at this point, more than 200 years old, and doesn't really reflect political realities now. So for that reason, we're talking about Arab Constitution and American Constitution, I like to put it aside in constitutional analysis and just say there's a lot of domination, intellectual domination of the field, because there are so many brilliant American constitutional law professors, but when they get to other countries, they usually do not understand what's going on. So that doesn't answer your question, but it explains why I'm not answering it directly.
Would you like to?
Yeah, the professor mentioned a very, very valid point about awareness and learning. It is actually. We learned, we got textbooks to know how to choose the right electoral system. Imagine, we didn't know anything about anything. But we learned ourselves through NGOs and professors, and we studied. We started studying. It was an amazing period. And also we learned from each other. So we learned from the Yemenis, we learned from the Tunisians, we had the interaction with the other colleagues in different countries in the region. So it was great. We would have learned more, actually, if there was no war at the time when the Constitution was in the process of drafting. And we would have learned more if the Committee of 60 opened their doors. And we would have learned more if they don't close their doors in this mountainous little city on the mountain and they stayed there and we didn't know anything about them. And we would learn more if they used technology. Technology is very important. And I wish we can have another lecture on technology and the constitution making process. It is very important and very, very, I think we cannot today go into the constitution making the old ways, the old-fashioned. Now you have to use technology to the maximum, and this is where you can make more learning with young people like you today.
And would you like, I mean, there was a question of learning, but also a great question, like, do we need certain institutions first before the constitution to guarantee implementations, or which comes
Why
first?
do I get the tough question? I mean, again, maybe Tunisia is useful in that respect. You need, I guess, a constitution to enable the establishment of those institutions you need. And again, Professor Brown referred to the Constitutional Court as such. That the Tunisians failed to establish such a court does not mean that that constitution should have not existed before a court was established, I would say. And had that court been in place, when the president invoked Article 80 to declare a state of exception, that court could have, well, held them in check and either assessed the existence of such exceptional measures and considered they were in place or not. So I mean, I do think that what we lack generally is a constitutional culture, and that can come with institutions that are novel. I mean, looking beyond the Arab world, I think Kenya is an example of a country that did establish a constitution first, that laid the ground for that culture to develop, and it has developed over the years, but the basis was laid in that constitution. But perhaps I'm biased because I always look at it from a constitutional lawyer's perspective. I'm sure Professor Brown has another perspective.
There's also the question we didn't answer about which Arab constitution is the closest to South Africa.
I guess I wanted to speak to learning experiences, and again, for example, with the Tunisian experience, what you saw is that when it came to adopting decision-making mechanisms within the Constitutional Assembly itself, they did look to other experiences, and this idea that you need qualified majorities, right, is not technical. What a qualified majority does is guarantee consensus, is to translate consensus, right? It's a mechanism to ensure that consensus is in place, in the absence of which you cannot get that constitution approved. And they copied that from the South Africans, because what they said is either the constitution is approved by the Assembly on the basis of 2/3 majority, or we go to a referendum. But only if it isn't approved, and that was an incentive to seek consensus within the Assembly, because had they not reached it, the Assembly would have been dissolved, and a new Assembly would have, again, begun that process. And I think we did not speak enough of content today, but when I think of what I saw as general trends or controversial topics that I'm sure were always latent, and Professor Brown spoke to that. The Arab world did not suddenly become divided because of the Arab Spring. It was just the first opportunity for it to express its divisions. They never got the chance, right? So one would be the question of the nature of the state and its relation to religion, civic state, secular state, religious state, Islam as a source of legislation, all of that. That would be, I think, a major challenge that all those countries face in one way or the other. And the other would be the question of decentralization or quasi-federalism or federalism. And of course, Libya was and has been struggling with that, but so has Yemen, and Sudan was not included, unfortunately, in this volume, but so is Sudan. And I would say these are the countries that will opt for some kind of federal arrangement. But so far, the Arab world had not witnessed any federal arrangements. I think maybe...
Can I just add one thing on the learning experience? Is that what I observed, that there's a lot of learning on what do we want, on the demands from the constitutions rather than the actual implementation. So in the Syrian example, for example, although the current process we have now is one that is led by the UN, but it also opened the debate for many people and organizations are expressing what do they want from that constitution. And you see a lot in these demands are a lot of learning from the other Arab contexts. For example, we learned a lot from the Iraqi ones. So first thing, they don't want one that is rushed. It was from the Iraqi and Egyptian experience that they're very firm, they don't want rushed one. They don't want muhassasa, kind of sectarian quota. On the issue of governance and federalization, they also learned from Iraq and the experience of the KRG. So you see a lot of reflection on this. And I think at the conference we had Mr. Faisal Al-Sabadi, he was always stressing this point that, learn from us and have interim constitutions. While you're in a crisis, don't write a constitution. Write some interim arrangement that will help you to go through that crisis period, have a national dialogue, resolve the issue, and then engage in a meaningful process, but don't rush it. So we see this really a lot in the debate. We wrote a paper about the Constitutional Court was another big learning. So I think we learned that from the Tunisian experience. So you see it a lot now in the demands of the Syrian experts, at least, that you have to pay attention from the outset to the Constitutional Court. This is not a trivial matter. And we did write a paper on this as well. So, do you want to say more, or shall I take more questions?
No, I just want to say that the best thing about the experience in the aftermath of the Arab Spring is that countries felt that they want to do their own constitution.
Yeah.
It's true that we want to have the other experiences and maybe have the textbooks of other constitutions, but and maybe this made things more difficult. This made things sometimes a failure because we wanted to do ours. And this is very important. And I think this is when I was talking about the 1951 was not ours. It was done under the auspices of the United Nations, and it was done very modern compared to Libya at the time in 1951. A small country, small population, very limited resources, if nothing actually at the time. But today there is, of course, this mechanism of disagreement and. Because we wanted to do our own constitution.
Thank you. More questions? So how many we have? So 3 in the back. Okay.
Thank you very much. Rupert Wallace, from alumnus of LSE. Can I just pick up on the gentleman's question about constitution chronology just here? And if the question's been answered, then you will tell me. But there are 3 countries in the world, as far as I know, with no written constitutions. New Zealand, Israel, and of course the country we're sitting in now. And I wonder therefore, particularly looking at Israel, as I understand, didn't write a constitution because it knew it could never get agreement on it. So it just rolls on a series of basic laws to this day. If the constitutions have all failed, as you've so well expounded, or appear to have failed or not succeeded, is there a role for actually not having a constitution in some of the countries that would be a better way around? Thank you.
Oh, sorry.
Good evening. Not that interesting the question. My question is not that interesting, but yours is very interesting. But so I do come from a country where the constitution has been not so respected, but verbal agreements through history have made their way to the statu quo and the power sharing a lot more than the constitution itself. And I think I'm from Lebanon.
Yes,
so verbal agreements in Lebanon play a role in our statu quo a lot more than the constitution itself, even though, especially in power sharing. Today, you might be able to be the cause of a civil war if you don't respect these verbal agreements in the country that's been happening through years. But if you breach the constitution, you would still see nothing happening. So my question is, even though we, especially aspiring youth or even the Lebanese population, generally speaking, we do want to get rid of these verbal agreements, but we can't. And even if we back our cause with the fact that these are anti-constitutional, we still cannot. So my question is, how can we do it if it's possible? Thank you.
So, this question on the merit, yeah.
Hi, thank you for the talk. Noura Mahmelji, health policy student. Well, my question is with regards to health. It's related to health policy, but it's also related to constitution because we see a lot of change happening right now in the Middle East, especially with healthcare reforms. From my research, I can see that there's a lot of healthcare changes happening. But I see there's a gap whereby there are, perhaps maybe you touched on this, there's a lot of work going on, a lot of things on paper, but then when it comes to the implementation, it's either not being effectively implemented or not really, or it's being prolonged. My question firstly is, as aspiring youth as well, how can we bridge that gap between what's written on paper and what's being implemented, and how can we increase the effectiveness of this implementation and reduce the inefficiencies that are happening per se? Yeah.
Thank you. So, question from Mary?
I didn't feel I got the answer to the question. You know, where do we go from here? What are the chances in the future? Given that this process was a really unique process, and actually you've made it sound very exciting, surely it must reverberate somehow despite the elites' pushback. And is the reverberation maybe something to do, was there perhaps a need for a more regional process or a more internationalized process so there could be leverage from the outside as well?
Okay,
Thank you. I want to perhaps build on the gentleman's question, really about the relationship between constitutional writing, constitutional development, and other institutions. And maybe just to ask how you see the constitution processes relating to rule of law. Because it strikes me that you do have pre-existing institutions, right? You do have political and legal cultures. So if you introduce a new constitution or make constitutional amendments in a country where, for example, a citizen can take the government to court, and the court can rule, yes, the government has acted illegally, that needs to change, versus one where that's not the case, it's a kind of a very different proposition. I mean, in the latter case, well, you could write a constitution, but does it really matter what it says? Similarly, if you're writing a constitution, it must come down a lot to the extent to which political elites who hold power are willing to have their power constrained in some way, to institutions to share power in some way. So I just wonder if you could say something about the relationship between the constitution and the pre-existing institutions of that nation. Thank you.
So I think we're going to stop here and have a round, and that will be the last chance. If you have any last thing to say, especially on the question of hope, where do we go from here? So who would like to start? Yeah.
Okay. This is time to break fast. So I will be very, very quick, I think. Number one, in terms of enforcement of constitutional texts and so on, I think one important point to remember is, yes, don't just focus on black letter law, but I'm sitting next to a lawyer, a law professor, keep the lawyers in the room, because how you draft these, and if you think through how these are going to operate, that's going to be important. Second, in terms of written constitution, non-written constitution, so I just want to, Jorge mentioned the idea of an interim constitution, some kind of iterative process where you draft constitutional principle, have an interim constitution, go back and forth. That's a device that's sort of a halfway house to an unwritten constitution, and that plays out the process. And third, there's a device that very few constitutions use, but that addresses some of the issues that people have talked about, and that is sunset clauses or time bombs in constitutions, things that don't go into effect for 20 years or that last for 20 years. And that's a device that is very rarely used, but can address some of the questions about the need for change and evolution.
Well, I'm sorry that you didn't get maybe a pessimistic view from my presentation. It was a bit quick, but I am very hopeful. I think this is history. We have to go through this, we have to go through this. But we will reach a point one day, and we learned, even if it seems negative, but we learned a lot. We learned where are the differences, how we can deal with them, and I think there is a will to reach that point. It's brewing. But I also think that we should not forget the foreign factor. Now, this is the region of sphere of influence. And the constitution is not a legal dogma, it is politics and social and a lot of things. And we cannot ignore that there are countries that are trying to interfere in this sphere, and there are problems in this and this region, and all of this has an implication on even on the constitutional process. So we're not in peace. We're not a peaceful region. We're not. We don't have our own destiny in our hands. And I always laugh when I hear the United Nations saying that this is a completely Libyan, process. This is in the hands of Libyans, and I look at my hands, and there's nothing in my hands these days. So I really wonder, That's it.
Nothing on the Lebanese example.
We can go on, I don't want to but I think on Lebanon, the one major mistake on learning was precisely that no interim arrangement was resorted to back then to manage that situation without entrenching those divisions and including them, incorporating them into the Constitution. At the same time, there were no sunset clauses, but there was, and you know well, the Constitution, as amended following the peace agreement in 1990, did contemplate transition toward a non-sectarian system, establishment of the second chamber within the parliament that would sort of channel sectarian representation and enable the first chamber to function as a chamber of popular representation. Perhaps, and this is something that other countries can learn from, instead of having just said this shall happen, a sunset clause establishing a time period by which this should have happened could have helped. But again, there was a time frame for Tunisia to establish a constitutional court. Who enforces the lack of implementation of a constitution in the absence of a constitutional court that isn't established? For Lebanon, I think the only answer is a full-fledged constitution making process. I do not think that via amendments or those are practices, but you can argue are constitutional conventions. They're part of that country's constitutional culture. So either you overhaul the whole system, both with regards to the written constitution and those practices that have developed. But honestly, the conditions, as you all know, are not there at the moment. Anyway, happy note.
Thank you so much, Tamara. I'm going to try and end on a happy note. On the question of hope, I'm also hopeful like Hazza. Because from the Syrian example, we do have actually successful experiences, and 3 examples of constitution-making experiences that had the hallmarks of legitimate constitutions, but from very long time ago. The first was in 1918. Yeah, so first 1918, 1919, and then 1928, and then 1950. And they were all written by elected assembly, reasonably representative, not fully, because of the nature of the state by then and the presence of the elites, urban elites, but it was reasonably representative. Exactly, and the debate as well. It didn't come from the top. I mean, there was a real debate on all the issues, all the relevant issues, including the role of the religion, this decentralization, distribution of wealth, and we have the minutes of all these debates. We have thousands of pages of every word that was said, and you could just look at it and wonder how. I mean, we have all this history, we have this really meaningful debate, and we did produce legitimate constitutions. But the first one didn't work because of the French, the second because of the French mandate as well, and the third one, I think it was a mix of Syrian failures with regional and international politics and military coups. But we do have successful experiences in the past. We look at them and we call them constitutional fathers in Syria. We still talk about it. So we know that we can do it. So it's been done through much more difficult contexts in the past. And we're happy that the debate is open now. And there's more action. There are more experts like you. We have a lot to learn from. And the story is not over. So thank you very much, everyone. I would like to ask you to join me in thanking our speakers and to continue the discussion with them over the reception.